Hello, everyone. My name is Shegun Oke, and today we'll be talking about giving ourselves a kind of the latest developments when it comes to EB1 and especially EB2, employment-based visa in the United States. There are new updates that we need to quickly check. As we all know that another administration is coming up, which is the president-elect will be swearing in this particular week, January 21st or thereabouts, and which is Donald Trump. And but before he get to the office, there is new updates by the USCIS that they just released and is on point, and which we need to, whether you're using Anthony to file your case or you are filing it by yourself. Remember, you are the architect of everything. The Anthony are just there to guide you and to, you know your field better than Anthony. So they are just to use the aspect of the law to come in to your application. So that's why I quickly do this video, and I want you to please make sure you watch this particular video to the end. Make sure you follow everything you see. I will share the slide also on you'll see the link to that update. They call it the policy update, the policy manual update, which we have discussed it in my previous video. So I want you guys to try as much as possible. Watch the video to the end, follow the slide. If anything is not clear, feel free to drop the comments. I will surely attend to that. And let me quickly share my screen, and so some of us will be able to. If you have any question, please do not hesitate to ask those questions. They are very key when it comes to these updates. So let's look at this. This is USCIS, as we can see, is dated to be January 15, policy alerts, second preference eligibility for national interest waiver petition. So I try to do a kind of summary at the end of the day, and you can see that this is taking effect immediately. Look at what they put here. It said, these guidance contained in volumes 6 of the policy manual is effective immediately and applies to the request pending. Probably you file your case and it's pending. It simply means this policy will affect it file on or after the publication date. The guidance contained in the policy manual is controlling and supersede any related guidance on these topics. So that now leads us into this. Let's look at this slide. So the policy updates by the USCIS, and so you don't need to be panic. You don't need to be worried, like I always tell us. So there are certain things you don't need to be afraid of. So U.S. Citizenship and Immigration Services, USCIS, issued new policy guidance on evaluating eligibility for national interest waiver for EB2, immigrant visa petition. These updates are, let's look at them one after the other. Then my name is Shegun Oke, like I mentioned. I'm not an Anthony, and I'm just using this based on my experience, just to educate ourselves If anything is not clear, especially for those of us that want to do it by ourselves, or you want to employ the Anthony. In my previous video, I shared when I did my own too, I actually use an Anthony, but I've guided people over the years that have done it by themselves and they got it. So you can also do it by yourself. And let's quickly look at the background for those of us that are seeing this for the first time. The background of EB2 clarification is advanced degree professional. They are still part of what they have us to do. That is the member of professional holding advanced degree or foreign equivalent degree. It might be advanced degree, probably your own might be bachelor and have 5 years professional experience after your bachelor degree. Probably you don't have, so you still qualify. But let's look at it. Exceptional ability, person of exceptional ability in science, arts, and business also can be part of exceptional ability. Labor certification requirements generally require job offer or labor certification, but national interest waiver can be exempt from this. So meaning that if you file for NIW, national interest waiver, you are exempted from job offers. But let's look at the new things that are coming up. So the new thing that are coming up is this. Whether demonstrating EB2 eligibility as an advanced degree professional or as a person exceptional ability, the petitioner must clearly describe in the straightforward manner the person, occupation, and proposed endeavor. So if you look at the footnote number 14 says, the intended occupation is the one through which the person plan to advance the proposed endeavor. And the proposed endeavor is more. So I will be talking about, but let's look at the foot 14, the one they put there. So USCIS recognized that many national interest waiver petitioners are involved in high technical occupation and proposed endeavor. However, it will be helpful to describe those in a way that an average person will understand. So it simply means you more ability to be able to communicate your proposed endeavor. That is a layman that is not technical person will pick it up and will understand what you are saying, what you want to do, not by giving us all these big grammar or more of technical terms that people will not be able to understand, or the officer in charge will not be able to understand what you are talking about. So just is plain English language that people can understand. Okay, for example, why the person with master's degree or PhD in engineering proposing an endeavor in the field of engineering may qualify as an advanced degree professional. A similar educated person who intends to start a bakery may have difficulty establishing that they are in advanced degree professional. Why the engineering degree is an advanced degree and the occupation of engineer is a profession. You can see the difference. The occupation of baker do not typically require a bachelor degree or its design foreign equivalent degree for entry into the occupation. The occupation, while underlying the endeavor, is determinative. So you can see, if you have PhD or masters in engineering and you're trying to argue your case, and somebody with establishing also trying to bake the bakery, that means the ability you need to do, you have to be able to communicate your idea with them. Look at that examples, the USCIS cited in page 8 of that manual. with respect to individuals who seek to qualify as an advanced degree professional based on the combination of bachelor degree and 5-year progressive experience equivalent degree. Absent of labor certification through which Department of Labor, DOL, has certified the job requirement, USCIS must necessarily review the proposed endeavor. The following paragraph discusses how USCIS experience in specialty in now. What this area is talking about is this: you have to be careful. If you have, let's say you have, I'll go to the example they cite in that particular area. It says, for example, you have a bachelor degree in chemistry, and they now ask you, you now claim that you already have 5 years progressive experience in that particular. You must have 5 years experience progress in that particular field. That is, if you are talking about bachelor degree now, then do you have 5 years working as a biochemist in a particular lab? You must have 5 years consecutive working in that field, not as a receptionist somewhere else. You say, oh, after all, I finished 5 years ago, and I've been working as a customer service somewhere else. I've been receiving, or I've been working in insurance company, but not in chemistry. They won't count that. So it must be, if that 5 years experience must be in that field. So let's take note of how we can claim that. So key policy changes is, that is, EB2 qualification first will be petitioner must first demonstrate qualification for underlying EB2 classification before national interest waiver eligibility. You must first of all have the clear understanding of that qualification first. Occupation as a professional, USCIS consider a case-by-case basis. They don't use general things to judge everybody. They deal with you as individual, your case-by-case basis. If occupation is a professional requiring at least bachelor degree, then they go for it. And you must have that normal experience in that field. Experience in specialty. For advanced degree equivalence or 5 years post-bachelor degree, experience must be in the specialty, you see, that I mentioned the other time. That is what I've been saying, and in my previous videos, and in what USCIS is late, because as at 2024, 2024, we have a lot of RFE and denial cases in EB2. Why? Because of this, what we are talking about. Exceptional ability relation. Area of exceptional ability must be directly related to proposed endeavor. You can't have disjoint application or disjoint, except you can say, I have exceptional ability, but it's not related to that proposed endeavor. The proposed endeavor is simply mean what you want to be doing after this, or what you intend to do to contribute to national importance in the United States. So you have to be able to state that. So let's look at the exceptional ability again. In the context of national interest waiver request, the claim area of exceptional ability must also be directly related to the person proposed endeavor. This is what they are talking about in the latest update. For example, a person who has a computer science education or experience that does not equate to definition of the advanced degree, and who's proposing an endeavor related to computer science, may qualify as a person with exceptional ability if USCIS determine that they have satisfied at least 3 of the 6 regulatory criteria. demonstrated by exceptional ability in an area such as computer science, which is directly related to their endeavor. So you can read more on, I will put the link also, the link will be in the video bio. Just click on that link and read more. However, if a person with the same credential were to propose an endeavor that does not relate to the area of computer science, that the person would generally not qualify for the classification, even if they have exceptional ability in that area of computer science. That means if you're a computer scientist and you are proposing something, or that probably you are talking about, okay, let's take as a computer scientist now, the area you are now proposing, probably you are talking about, it might be Scrum Masters or project management, and you don't have the degree in that area, or probably you are talking about, as a computer science, you're talking about programming language now. You're thinking about how to write the code. Hey, that one is related to what you are doing. Or you're talking about you're a software engineer, it's related. You're talking about system engineer, is related. You are proposing to be a system engineer, robotic operators is related. But if you are now taking it out of the area, probably as a computer scientist, you are now talking about the other, propose something that are not related to computer science. So that's what they are talking about here. Let's just look at it critically and be able to guide ourselves and guide your lawyer, or probably your employer, or somebody filing for you. In the context of national interest waiver, require the claim area of exceptional ability must also be directly related to the person proposed endeavor. For example, a person with computer science that I've explained the other time, and however, all these conditions are stated, we have to be careful about it. So now let's look at we have the three-pronged for us to be able to scale through. Out of the three-pronged is the framework for the national interest waiver. Number one is substantial merit and national importance. That is, the proposed endeavor must have both substantial merit and national interest and national importance. Two, well-positioned to advance. That is, the person must be well-positioned to advance and propose endeavor. Three, balancing text. That is, on balance, it must be beneficial to waive the job offer and the labor certification requirements. So all these three must be met before for these. When it comes to national interest waiver. So let's look at it. Prong one. What has changed in prong one? It says substantial merit and national importance can be demonstrated in the area including the business, entrepreneurship, science, technology, culture, health, or education. Does not require immediate economic impact. Take note. National importance, consider potential prospective impact, may have national or global implication within a field. Significant potential to employ a U.S. worker or other substantial positive economic effect. Now, let's look at what changed. Is that, for example, a proposed endeavor to engage in classroom teaching without broader implication for a field or region generally does not rise to the level of having national interest. So that it does not rise to the level of national importance for the purpose of establishing eligibility of national interest waiver. You have to be careful when you are stating this. Teaching in classroom might not be the one. They are talking about internal issue. Citing the general importance or profession of classroom teaching will not alone be sufficient to demonstrate national importance in the context of national interest waiver NIW request. Proposing to work in an occupation with a national shortage of staff of consulting capacity for others seeking to work in an occupation with national shortage alone is also insufficient. So, I mentioned in some video that don't say because you have a shortage, you are not the one to fill the shortage, it's the Department of Labor that does that. So you don't need to mention that oh, they have shortage in this. What do you use to measure that? So they might have the shortage, but not your own to put the shortage. You can deal with your degree. You can deal with your own law. That's why they mentioned, look at the way they explain the one of computer science. Then the other, you must be able to prove yourself based on your advanced degree and your relevance and your with your proposed endeavor, not using classroom, not say, oh, I will be teaching because they have teachers shortage, I will be doing this. No, don't use your occupation to argue your case. So they said it here that profession of classroom teaching will not alone be sufficient to demonstrate national importance. So you must have, how do we claim the national importance? So you can read this matter of the NASA here and see the aim of sufficient scientific knowledge for further security interests and U.S. competitive and civil space, and therefore has a substantial merit. Look at footnote number 4. Find those that have substantial merit to be able to argue your case. And look at number 41, also said, finding that a certain locally or regional focus endeavor may be of national importance despite being difficult to quantify with respect of geographical scope. So you have to read this and be able to identify don't just say, oh, I'll be teaching as a teacher, as an educationist, as a mathematician, I'll be teaching. No, that one is not sufficient enough to argue your case. That is what they are telling us here. That is, that national shortage alone is also insufficient. Don't use statistics that, oh, we have this, it's not enough. It is not enough. So prong 2, we have to argue well-positioned, also well-positioned to advance the endeavor, that is education, skill, and knowledge. The person, education, skill, knowledge, and record of success is related effort. Detailed plan or evidence of a plan for future activities related to the proposed endeavor. Then progress and support any progress towards achieving the endeavor and interest for relevant entity or person. Now, this is where the issue of letter and business plan comes in. That is, letter may be persuasive when they are from experts in the field. That's why recommendation letter is key. You need to know how they will write your recommendation letter. If you are writing in, if anybody that is giving you recommendation letter, the element that must be there, you have to be careful in that aspect. That is, when they are writing, you must get a letter from experts in the person's field who has first-hand knowledge of the person achievement, describe the achievement. This is not my own write-up. This is from USCIS, what they want to see in the letter. describe those achievements, provide specific examples for how the person is well positioned to advance the person endeavor, and are supported by other independent evidence, business plan, or other similar description of the person's plan. Why useful? Explaining the person objective should be supported by other independent evidence. In the case of in each case, officer must consider, look at it, the totality of circumstances to determine whether the preponderance evidence establishes that the person is well positioned to advance in proposed endeavor. USCIS decide each petition on a case-by-case, okay, basis. You can't just say, oh, you pick somebody else's petition and say, oh, it's suitable because we studied the same thing. No, you don't have the same experience. You've not worked the same place. You don't have you can have the same degree, but do you publish the same paper? Do you publish the same article? Or do you have the same link, the same network? So, or you can be doing the same business, but it's different, the angle you are looking at it. And the more integral as a person to an endeavor, the stronger the case to person present that they are well positioned to advance the endeavor. So the prong 3 says is talking about the prong 3 is talking about balancing test. That is, in practicality of labor certification, consider if obtaining a labor certification will be impractical for you, benefits to the United States. That's a major thing. Evaluating benefits from person's contribution, even if United States workers are available. Urgency of contribution. Assess if national interest in person contribution warrants foregoing labor certification. So, factor of shortage. Your letter, as I explained the other time, though the issue of shortage should not also come in at all. That, oh, you are shortage this and that. So in this case now, they said the national interest in the person contribution is sufficiently urgent to warrant foregoing the labor certification process, such as at a time sensitive public health or safety benefit offered by the endeavor. So all this needs to be taken care of. You must more specific consideration may be include whether the labor certification process may prevent or an employer from hiring a person with unique knowledge or seek exceeding the minimum requirement standard for that occupation, which cannot be approximately captured by the labor certification. So they also have different other things we need to also read. Now, for those of us in STEM consideration, that does not mean they cannot deny or they cannot have RFE. You must be able to compete and write a good proposed endeavor. USCIS recognize when it comes to critical technology, recognizes importance of progress in STEM field, especially in critical and emerging technologies. Then competitiveness, US consider STEM area importance to the United States, competitiveness or national security. Then when it comes to strong positive factor, advanced STEM degree, work in critical technology, and being well positioned to advance STEM and endeavor on national importance. They are for the fact that you just have to place those areas. Okay, let's look at what has changed in different areas. When it comes to STEM, you need to identify a critical and emerging technology field. Officer consider governmental, academics, and other authoritative and instructive sources, and all other evidence submitted by the petitioner. The list of critical and emerging technology subfield published by the Executive Office of the President, by either the National Science and Technology. You need to look for those materials and check. I will also try and put the link on my bio so that you can check the list. For example, the authoritative list for when it comes to the STEM area. The role of government agencies support the letter from agency, the letter from interested government agency or governmental entity can provide a strong evidence supporting national interest waiver eligibility. USCIS consider the factors such as agency experts, the degree of interest expressed, and any government or public resources commitment described. So, but when it comes to entrepreneurship contribution consideration, a lot of things are also going on. Entrepreneur may have unique aspect of evidence related to their proposed endeavor. Then typically process ownership interests and maintain active central role in the US-based entity. Not automatic qualification, that is, not even entrepreneur qualifies. Broad assertion about economic benefits are insufficient. Don't just say, oh, it will be for the economic, this and that. No, there are the latest things we need to also consider. That part of things we need to consider as an entrepreneur is specific evidentiary consideration for entrepreneur. There are so many things that we need to read and look at the example. He said there may be unique aspects of evidence submitted by an entrepreneur petitioner. Undertaking a proposed endeavor is beyond, now this area is beyond business plan alone. So your ability to be able to argue your case and be able to of a national importance and write a good proposed endeavor in United States, it's a typical thing. Not every entrepreneur qualifies for national interest waiver. Look at it. While USCIS decide each case on its merits, board as action regarding general benefits to the economy and potential to create jobs will not establish an entrepreneur qualification for national interest waiver. You can't just say, oh, I want to create a job. They decide who and who in that part, in that category. For example, an entrepreneur cannot demonstrate national importance under the first prong. So we mentioned the first prong the other time, solely by opening a consulting firm for those working or seeking to work in the national importance occupation. No, you can't just say that. Similarly, statement and evidence regarding an importance of the relevant industry overhaul, such as the car dealership industry, will not demonstrate that a person seeking to start a car dealership satisfy the national importance prong. So you have to be careful when they are filing the case for you. So there are so many things to evaluate entrepreneur. Evaluating entrepreneur petition. Number one is ownership and role. The evidence of ownership, interest, and active central role in the United-based entity. Investment, that is outside investment or commitments consistent with industry standard. Growth metric, revenue generation, job creation, and other relevant growth metric. So it's a dicey things that the evidence of entrepreneur petition. Number one, business documents. Formation documents, ownership record, role description, financial record, investment agreement, revenue report, financial projection, job creation data, market analysis, then expansion. They give an example here. They said an example related to second prong, evident that a person has general work experience in a given field may not be sufficient to demonstrate that such person is well positioned to start a consulting business providing experts in the field. So for instance, if a person experience in banking is limited to working as a teller or account manager, USCIS may determine that the person has not established they are well positioned to advance the entrepreneurial endeavor, to establish a consulting firm that will advise US bank, nationally, or how to improve customer relation. Because you only have one experience, as a teller or as an account manager. So how do you consult in that area? So evidence, evaluating all evidence in aggregate, USCIS evaluates all evidence in the aggregate when determining eligibility for national interest waiver. So not every piece of evidence necessarily establishes eligibility on its own. Officer review the petition, the person education, experience, the skill, the potential to the national interest. So you have to have a strong petition. It's there in the update. So a strong petition would discuss how the person record of sources would translate to a proposed plan or forecast for continued success and step they have taken towards those proposed activities and plans that tie into the person background and experience. You have to be careful. Your attorney or your lawyer must be able to argue your case, and your petition you must read too. Some of us, when we have an attorney, we believe they are all. They made mistakes too. So that's why your own input is matter when it comes to this particular area. So we are ability to be able to argue your case, give others to read and digest it. When evaluating whether petition for entrepreneur certify the three-pronged framework, officer may consider the fact that many entrepreneurs do not follow traditional career paths, and there is no single way in which an entrepreneurial venue entity must be structured. So let's look at the takeaway. So we just have to balance it. One of the key takeaway for today's update is number one, EB2 qualification first. Number two, the three-pronged framework. Number three is a case-by-case evaluation. We just have to know it's a case-by-case evaluation. Don't forget that. It's very, very important. effective dates don't, like I mentioned in the beginning of this video, the effective day and implementation of this is the guidance is effective immediately and apply to all pending and future national interest waiver petition. For as many of us that are filing for EB2, please take note. In case you have your RFE also, when you are replying to the RFE is not a crime. I had RFE during my time, and we sat down again. I go through all the protocol, all the procedure, and I make sure I put everything one by one. Don't be panic. All you need to is remember this EB1, EB2, EB3, and so on. They are evidence-based. So it's not that, oh, having a degree like they mentioned in their documents in the all new update, having advanced degree is not insufficient enough. You must have a relevant experience and ability to be able to work towards all these are key into the submitting our national interest waiver request. Like I mentioned, I'm not an attorney. I'm just someone like you, just to try to make an impact and try to give my little update, little one that I know, to my viewer, and for us to also benefit from it. I believe this little piece that I just share will help as many of us that are also in line that are doing this for now. It will help us and it will guide all these the guidance, the new updates will help our case. And I believe that at the end of the day, success is our portion. Yes, Donald Trump is coming in. You have nothing to be afraid of. All you need to do is make sure you argue your case, follow the guidelines, follow all those links. If you don't have the link, please go to the bio of this particular. If you're not part of the community, please subscribe to the channel and try as much as possible. Follow for more updates in this time. Thank you so much for being here with us for today. I remain Shegun Okay, and like I told you, I'm a scientist. I'm a mathematician. I'm a professor of mathematics, and we are just doing this for the sake of encouraging ourselves, for the sake of education. Thank you so much. Bye for now.